Now.
On 105.9 FM and streaming worldwide on the WMAL app.
O'Connor and Company.
7:37, and it's O'Connor and Company on this Tuesday morning. Thanks so much for tuning in. Coming up at 8:05, we'll speak with Senator Roger Marshall of Kansas. Joining us right now, though, and by us I mean myself and Julie Gunlock, it's Jesse Binnall. He's a former attorney for Donald Trump, and we're asking him for his expert analysis of what's going on there in the trial in New York. By the way, Jesse, thanks for joining us, sir. Good to talk with you.
Yeah, thanks so much for having me this morning.
I know you do legal analysis here and on various outlets. Does it drive you as nuts as it drives me nuts when they say, now let's the latest on the hush money trial?
Yeah.
It's not hush money. This is, if anything, this is a trial about falsifying financial records. But, you know, it's a payment for a non-disclosure agreement, which is not illegal. There is nothing in any of the 34 charges that actually says that the payments were illegal. But there's a reason why they're doing that, right? They want to make it sound tawdry and illegal. I mean, even
Scandal.
AP, NPR, these are, you know, it's factually inaccurate, isn't it?
No, it's absolutely factually inaccurate, but it's of course what we've come to expect, from corporate news media on this is that it's a pithy way for them to really lie about exactly what this case is about. And really what this case is about is Biden team going after Donald Trump by, putting one of their prosecutors in a county district attorney's office, a top prosecutor from the Department of Justice, number 3 over there, in a county district attorney's office to pursue their political opponent. It's just, that's what this case is about.
They were talking about Mr. Colangelo. And by the way, it was revealed yesterday that based on public financial disclosures, he literally was paid by the Democratic National Committee for consultation. So, he was a political appointee of Biden and Merrick Garland in the Justice Department. He leaves to become a county prosecutor in Manhattan, which is a bit of a step down, and he was on the payroll of the DNC. This sure looks like a political trial, not a trial that has anything to do with the law.
Yeah, that's exactly right. This is a guy that is truly, truly a political hack. In this country, you're not supposed to allow prosecutors to decide they're going to move around from department to department, from office to office, in order to try to pursue somebody based on their politics. Mm-hmm. Prosecutors are supposed to pursue specific offenses, not specific individuals. Mm-hmm. And the Supreme Court has been very, very clear that the job of a prosecutor is only to pursue justice, not pursue convictions. But what we see here, not only, of course, in this case, but in each and every one of the cases against President Trump, is you have left-wing prosecutors that are using their positions as prosecutors to achieve a political aim. Here's the ironic thing here, is that their theory of the case, Colangelo's theory of the case in this New York case, is that yes, a non-disclosure agreement is normally legal, but in this case, it was done with the goal of helping him politically, and so it was an unlawful campaign contribution. Now, let's ignore the fact that campaign finance experts completely reject that theory. If that is true, then what they are doing right now, using taxpayer money in order to pursue a presidential candidate for the benefit of a presidential election, is the unlawful use of public funds in a presidential campaign.
That's a good point.
Right.
Because it helps Joe Biden.
Exactly. And we all know that's what their goal is.
Yeah.
So,
Mr. Binnall, can I just, you just said you're not supposed to do this and you are supposed to do this. You talked about the Supreme Court being clear. And, I'm a non-lawyer here, right? I'm watching this.
Congratulations.
I made good choices. But then tell me why. Why is the legal profession allowing this to happen? Who can stop this? This is what frustrates a lot of people is, every week we have people coming on and talking about these cases, which are just bogus, from Fannie Willis to, the Alvin Bragg to all of them. They're so bogus, and there seems to be no stopping this. What will stop this?
What will stop this is when our side decides to give up unilateral disarmament. That's what's going to stop this, because right now the left gets away with murder. Yeah. They get away. They know that nobody in New York is going to step them back on this. They know that the D.C. courts absolutely hate Donald Trump. They know that at least they think, there's not going to be any accountability. And so they feel free to go and violate people's civil rights under color of law, even though violation of civil rights under color of law is a very clear federal offense, and conspiracy to do so is also a clear federal offense. So the only way to stop this is when President Trump wins again, we need to make sure that there are people in the Department of Justice that will pursue accountability. And people have called it revenge. I don't think it's revenge at all.
Right.
Right.
Well, that's how they'll paint it. Oh, he's got power now, and this dictator is now going to clear the courts and punish judges who went after him. But some sort of there needs to be some sort of guidelines and rails that our system works within. Otherwise, the only other alternative is Trump then tells our lawyers to do to them what they did to us, as you just called it, unilateral disarmament. Doesn't the Supreme Court have something? The Supreme Court is the highest court in the land, and don't they have certain jurisdiction over judicial misconduct?
Well, I mean, it depends. If it has to do with like federal civil rights and constitutional rights, then yes, they are always the final say. But you got to get the case to them, and then they have to decide that they want to take the case.
Okay, but they don't have any sort of proactive. If Chief Justice John Roberts sees something happening in a U.S. courtroom that is clearly wrong, unprecedented, and stretches the boundaries of what we've known in our 250 years of jurisprudence, he can't just say, well, he can't call the judge and say, what the hell are you doing there? You're warping the entire Constitution. He can't proactively or prophylactically go in there and prevent something from happening.
That's right. He cannot do that. He is constitutionally prohibited from going and inserting himself into any disputes unless they come to him. It's called the Case and Controversies Clause in the Constitution, and it means that the only way the Supreme Court or any court in this country is supposed to act is when someone brings them the dispute.
Gotcha. Can we also quickly talk about this gag order, which seems, Michael, Donald Trump was just fined $1,000 and threatened with jail time because he said publicly that Michael Cohen is a perjurer and has told lies the last time he testified. That is a fact. He was jailed for perjury. Yeah. How can that then garner a fine? Unilateral, no jury says this. The judge just uses his power. Is that normal?
No, it's not normal at all. To the extent gag orders are ever constitutional, they're only constitutional really to gag the government, gag the prosecutors from affecting the constitutional rights of the defense. Because otherwise what you have is a prior restraint on speech, and that is primarily what the founders were concerned about. The founders were really concerned about governments putting in indictments, injunctions to stop people from speaking, and political speech. And they actually have both here, where you have a candidate for president, a campaign for the presidency that is being told what they can and cannot put on their website, what they can and cannot communicate to the American people. That's never happened before.
The judge and the prosecutors claim it's necessary here because of the things that Trump says it will inspire some sort of threat or violence against witnesses, the judge, the prosecutor. They say that it's needed here because to preemptively keep a violent act from happening or intimidation.
Yeah, that's complete hogwash. First of all, there's absolutely no basis for it. But, second of all, let's look at the robustness of the First Amendment. Let's look at the fact that in the 70s, when the Washington Post and the New York Times wanted to publish classified information that would have did put American lives in jeopardy, and the Department of Defense wanted an injunction to stop them from publishing the classified information, the United States Supreme Court said, no, you can't have that prior restraint. So this is something where it's a Trump rule again. It's that you have judges like Merchan that clearly believe Donald Trump is below the Constitution. that he is not entitled to the constitutional rights that have been clearly established.
Wow. All right. Thank you very much.
Yeah, it's extremely dangerous.
Really informative stuff, Jesse Binnall. Thank you so much for joining us on this, and we'll talk with you again as this develops. Thank you, sir.
Thanks so much for having me.
You bet.